A terror arrest is only the beginning. After the handcuffs come interviews, digital forensics, charging decisions, and court proceedings. So what actually happens after someone is arrested under UK terrorism law? This is the legal phase of the counter-terror system, and it's where intelligence must become evidence. After arrest, the suspect is taken into custody. Under terrorism legislation, police can detain a suspect for extended questioning. This period allows investigators to assess evidence quickly. Interviews are recorded, legal representation is provided, and strict procedural safeguards apply. At the same time, digital forensic teams begin work immediately. Phones, laptops, storage devices, cloud accounts, every device becomes potential evidence, because from this moment forward, the standard is no longer intelligence, it is proof. The Crown Prosecution Service, or CPS, is independent from the police. Police investigate. The CPS decides whether to charge. Prosecutors review the evidence gathered. They apply a legal test. First, is there sufficient evidence for a realistic prospect of conviction? Second, is prosecution in the public interest? If both tests are met, charges are authorised. If not, suspects may be released, or further investigation may continue. This separation protects the integrity of the system. UK terrorism legislation covers a wide range of offences: preparation of terrorist acts, possession of materials, dissemination of extremist publications, funding, training, encouragement, membership of a prescribed organisation. Some offences relate to planning, others relate to support. Some cases involve direct attack preparation, others involve online radicalisation or facilitation. Each charge must meet a specific legal threshold, and evidence must be admissible in court. In serious terrorism cases, detention can be extended with judicial approval. This allows more time for forensic analysis, encrypted devices, large data volumes, international intelligence checks. But detention is not indefinite. Strict timelines apply. If evidence meets the charging threshold, formal charges are brought. If not, the suspect must be released, even in high-profile cases, because the legal standard remains constant. Terrorism cases usually begin at a Magistrates Court. They are then transferred to the Crown Court for trial. Judges oversee procedure. Juries determine guilt. Some evidence may be sensitive. In rare cases, certain intelligence material is handled through special legal mechanisms, but the fundamental structure remains the same as other serious criminal trials. Evidence is presented, witnesses testify, defence counsel challenges the case, and the jury reaches a verdict. Sentences, if imposed, can be severe, including long custodial terms. Not every arrest leads to conviction. Some suspects are released without charge. Some are charged with non-terrorism offences. Some cases collapse due to insufficient admissible evidence. This does not always mean the threat was imagined. It reflects the difference between intelligence and courtroom proof. Counter-terror policing operates in a preventative space. The courts operate in a legal one. Those standards are deliberately different. So when you see a terror arrest in the UK, it marks the transition from intelligence to law, from surveillance to scrutiny, from disruption to due process. The Crown Prosecution Service does not measure risk, it measures evidence, and the court does not assess threat levels, it determines guilt. Together, they form the final stage of the UK counter-terror system. In the next video, we'll examine how terrorism cases are defended in court, and how defence strategy works in high-security trials.